Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with a special immigration report. Deportation inoculation warnings. Why you must file for U.S. citizenship now. In the United States, millions of lawful permanent residents, green card holders, are eligible to become U.S. citizens but fail to do so. Many delay filing for naturalization due to fear, procrastination, misinformation, or simply not realizing the urgency. However, waiting too long to apply could expose you and your family to severe risks, including deportation. This article serves as a wake-up call. If you or your children qualify for U.S. citizenship, applying now is not just an option, it's a necessity. Delaying your application leaves you vulnerable to deportation, especially if you ever face legal trouble. Worse yet, your children who qualify for derivative citizenship may also face unintended consequences, including the possibility of being permanently expelled from the only country they've ever known. If you think deportation could never happen to you or your family, think again. Let this serve as your official warning. Part 1. The hidden dangers of remaining a green card holder. While having a green card provides stability, it is not permanent security. Many longtime green card holders have been deported for reasons they never imagined. Here's why. 1. Green card holders can be deported for criminal convictions. A U.S. citizen cannot be deported except in rare cases of fraud or treason, but green card holders, they can be deported for a single mistake. Under U.S. immigration law, lawful permanent residents can be removed if they are convicted of certain crimes, including drug offenses, even possession of marijuana, theft or fraud, even minor shoplifting, DUI, driving under the influence with aggravating factors, domestic violence or assault, gun-related offenses, any crime labeled as an aggravated felony or crime of moral turpitude. Even long-term green card holders who came to the U.S. as children have been deported for offenses they never expected would trigger removal. Scary fact. If you're a green card holder and you are convicted of a deportable offense, ICE, Immigration and Customs Enforcement does not care how long you have lived here or whether you have U.S. citizen children, a home, or a family. They can and will detain and deport you. 2. Even minor legal issues can trigger removal proceedings. Some green card holders don't realize that certain nonviolent offenses can still result in deportation. For example, if you are caught with even a small amount of drugs, you could be barred from citizenship and put into deportation proceedings. A DUI, reckless driving, or fraud charge could put your future at risk. Even failing to update your address with USCIS can technically result in deportation proceedings. Too many green card holders believe this could never happen to me until they get arrested, flagged by immigration, and find themselves in an ICE detention center with no way back. 3. Leaving the U.S. can be risky. Did you know that even brief international travel can put a green card holder at risk of being denied re-entry? If you travel outside the U.S. and border officials discover a past arrest or crime, they can block you from returning, even if you were never convicted or served your sentence years ago. If you are a U.S. citizen, you have the absolute right to re-enter the country. If you are only a green card holder, you do not. Part 2. Your children may be at risk too. If you are a green card holder and have children under 18, they may qualify for automatic derivative U.S. citizenship. However, many parents never apply, leaving their children exposed to the same deportation dangers if they ever run into legal trouble. 1. What is derivative citizenship? Derivative citizenship allows children of U.S. citizens to automatically acquire citizenship, provided certain conditions are met. Generally, a child qualifies if one or both parents are U.S. citizens, the child is under 18 years old, the child is living with the U.S. citizen parent in the U.S. But here's the problem. If parents don't apply, the child remains a green card holder and subject to deportation risks. 2. What happens if a child commits a crime? Most parents never imagine their children getting in trouble with the law, but reality proves otherwise. Teens often make reckless decisions, shoplifting, fights, drug use, DUIs. Young adults can get into legal trouble without realizing the consequences. Here's the nightmare scenario. A 17-year-old with a green card gets arrested for possession of marijuana or shoplifting. A conviction makes them deportable, even if they've lived in the U.S. their entire life. ICE detains them, strips them of their green card, and deports them, permanently separating them from their family. Solution? If you apply for their derivative citizenship before they turn 18, they become U.S. citizens, meaning they can never be deported. Part 3. The solution. Apply for citizenship now. There is only one guaranteed way to prevent deportation risks for yourself and your children. Apply for U.S. citizenship as soon as you are eligible. 1. The benefits of becoming a U.S. citizen. You can never be deported. No matter what happens, your legal status can never be revoked. You gain full rights, you can vote, apply for federal jobs, and enjoy full protections under U.S. law. Travel freely, no more worrying about being denied re-entry after a trip abroad. Protect your children. They may qualify for automatic citizenship, shielding them from deportation risks. 2. How to apply for U.S. citizenship. Filing for naturalization is easier than you think. Here's the process. Step 1. Check your eligibility. You must be at least 18 years old. You must have had your green card for at least 5 years, or 3 years if married to a U.S. citizen. You must have lived in the U.S. for most of the past 5 years. Step 2. Submit Form N-400. File Form N-400. Application for naturalization with USCIS. Pay the $640 fee waivers available. Submit fingerprints for a background check. Step 3. Attend your citizenship interview. Take an English and civics test. Exceptions apply for older applicants. Answer questions about your background. Step 4. Take the oath of allegiance. Once approved, attend a naturalization ceremony. You receive a certificate of naturalization, making you an official U.S. citizen. Final warning, don't wait until it's too late. Every year, thousands of green card holders and their children are deported, many of whom could have avoided it by applying for citizenship sooner. Don't assume you have more time. Don't wait until you or your child get into trouble. Don't risk your future. If you are eligible for U.S. citizenship, apply now. If your children qualify for derivative citizenship, file immediately. The stakes are too high to delay. Protect yourself, protect your family, become a U.S. citizen today.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa & Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.